61 of the Inland Empire Workers' Compensation Lawyer live stream podcast. We're going to be talking about the 3 main things that are necessary to collect benefits. These are the requirements that must be met before a worker can collect workers' compensation benefits. So, George, what's the main question that people are always asking themselves, when they've been hurt at work?
Alex, I do a lot of things to try to get out there and talk to the public about what their rights are, what benefits they qualify for. But it doesn't matter how long I've been doing this or how many times I try to go out there to the Mexican consulate, to different events. We do videos about this, right? It doesn't matter how many times you say it. It seems like people are still scared of trying to fight for their rights. And their main question is, do I qualify for any type of benefits? Yeah, I was hurt at work, but I don't have a social. I was hurt at work, but I'm working under a different name. I was hurt at work, but I'm not, my legal status in this country is not exactly 100%. None of that matters. Now, we're going to talk about the 3 main things today that you need to ensure you have in order to qualify for benefits. But remember, these are the main things. There's other things that might come into play, whether or not you were drunk while you got hurt at work. That might be an issue, right? Other things that come into play. But these are the 3 main things that come into play when you are hurt at work. And if you have these 3 main things, most likely you're able to receive benefits, which include temporary disability benefits while you're getting better, medical treatment, and possibly some compensation at the end of your claim. And even future medical treatment for life. It depends on what you want to do. But these are the 3 main things. Alex, what's the first thing that they need to know that they need to have or be or qualify for in order to get these benefits?
Well, you're going to need to be an employee of an employer.
Right.
So there's a distinction between being an employee and being an independent contractor. And you might be being misclassified. But in California, only employees have workers' compensation rights under the labor code.
Yeah, and I feel the title workers' compensation might be a little misleading because a subcontractor is a worker,
right?
But he's not an employee. If I could have it my way, it would be changed to employees' compensation benefits because you have to be an employee, not a worker, employee, not a subcontractor, in order to obtain these benefits. Okay, so what makes someone an employee versus a contractor, Alex, or something other than an employee?
Well, the main aspect of being an employee is that your employer exerts control over your work duties and your work product. So an independent contractor is hired for a job on a contract, and the person who they're contracting with, if they don't meet the specifications of that contract, however they decide to perform it, then they don't get paid. Right. But if you're an employee, you're being told you show up at a certain time, you do certain tasks, this is how it's done.
Maybe wear a uniform.
Wear a uniform, that's a good one.
Yeah.
Those types of things make you an employee, and to know if your employer is paying you by a paycheck and you have a W-2, that's going to be a good indication that you are classified correctly as an employee and that your employer has workers' compensation insurance.
That's very, very good information, Alex, and entirely correct. A lot of people don't realize what the difference between an employee and a subcontractor is, or just a worker that contracts with the main. I don't want to call him employer, but the main person doing the job. So let's give the people an example. What if there's a construction company and they hire you to just paint the window seals, and they give you a certain amount of money, and they give you a certain amount of time to do it, but they don't care how you do it. And you don't have to wear their uniform. You don't have to explain when you do it. You just have to get it done by a certain amount of time. Is that, would you classify, just with those facts, as an employee or maybe a subcontractor?
That's pointing towards a subcontractor, in my opinion, because they're not exercising control of when and how you do the work.
Right.
They're not in the business of putting those seals on, although they are ultimately in the construction business.
That's a very good
point. That factor points towards that.
Right.
But it also depends. If you're doing it for them on every single job that they're doing, could start pointing towards being an employee.
Right. And, these distinctions are very, very subtle. So I wouldn't really want a layperson to make that distinction. Hey, am I a subcontractor or am I an employee? Now, there's very clear ways to define an employee. So once again, Alex mentioned you receive a paycheck with the name of the company, and it's, on a continuous basis, every 2 weeks, every month, or every week, whatever the case might be. You have to wear a uniform. You have to abide by the hours. You have to show up at a certain time and be done by a certain time. All those things point to you being an employee, very, very strong indications that you're an employee. But once again, there's very subtle distinctions that you have to take into account where you don't always know whether you're an employee or whether you're not. Now, one thing that makes it very, very difficult. So if you're doing this, just know if you get hurt, it might make it very difficult for you to prove a claim is getting paid by cash, getting paid on the table. Because what happens then, Alex, and I'm sure you've had this happen to you before, I've had it happen many times, is the employer, or what we choose to call an employer, and they're saying they're not an employer, they're going to come in and say, we never employed this person. We might have given them cash here and there, but we never employed them. We don't pay them with a check. We don't provide a W-2. If anything, we might provide them with a 1099. These are all technical terms, tax terms, but a 1099 means that you're not an employee. W-2, usually you are an employee.
If you're being paid by cash, then it's pretty clear that your employer is not reporting you to their workers' compensation insurance company, because every year the employer has an audit and has to put down their payroll, who they're paying, and who's basically an employee and who's not an employee. And if you're being paid cash, there's no withholdings. You're being 1099.
Right.
And that's not an employment relationship, at least not from the employer's perspective. Now, the law might say differently.
Yeah.
But if you're being miscategorized, it's likely that there's no insurance that the employer is going to have for you. Now, it may be that the insurance carrier will pick up that claim, but you're going to have to prove it. You're going to need a lawyer.
So the first thing is, are you an employee or are you not? If you're an employee, you've met the first qualification out of the three main ones we're going to talk about. But Alex, you mentioned something very interesting. You talked about taxes and audits, and they have to have workers' compensation insurance.
Right.
So that's the second part of our discussion today. Your employer must have workers' compensation insurance. It's the law. Alex, can you tell us a little bit about that?
Yeah, every employer in California has to have the workers' compensation insurance, or they have to be legally, self-insured or legally uninsured.
Permissibly self-insured, PSI.
Self-insured, yes. So if they are a very big employer and they have their own risk management department, it may be that they put up the money and they're saying we're good for it, so we don't need to buy insurance from someone else. An example of that is like Disneyland.
Now, although we say that every company should have workers' compensation insurance, the truth is that a lot of them don't. So, Alex, if that's the case, and you need to have a company that you work for, we already established that you're an employee, and need to have workers' compensation insurance, what happens if they don't?
Well, that's a very bad day for you, because workers' compensation insurance is what pays you. And if the employer doesn't have it, then you got to get it directly from the employer somehow. You got to file a civil claim potentially if your employer was negligent. But keep in mind that workers' comp's a no-fault system, and it pays you ongoing benefits. And without an insurance company to pay you there, you're just kind of left without any help. I mean, there is the protection of the uninsured employer benefit trust fund. It's very difficult to get money from that fund.
Very difficult, Alex. Let me just tell you that
cases going for years and
years
and
years. UEBTF, like Alex mentioned, uninsured employer benefit trust fund. It's the most complicated thing to do. A lot of attorneys won't even do it anymore. They won't even touch it, to be honest with you. I've spoken to a lot of peers and a lot of other attorneys, and they just will not take a UEBTF case because it's very hard to do. Now, the ones I've spoken to, Alex, will take it on a civil claim basis. So they'll go straight to the owner of the business and go after their assets, right? And that's a different type of legal situation than a workers' compensation claim. Either way, it's very difficult to do. If your employer doesn't have insurance, you don't meet the second requirement, and it's going to be very hard for you to get workers' compensation benefits. Still possible, but very difficult. Which leads us to the last part, which is, in essence, well, actually all three are very, very important, but the injury, was it work-related?
Right.
We call this industrial. The causation would be industrial. It's work-related. It's also AOE-COE. What does AOE-COE mean, Alex?
arising out of employment and in the course of employment.
Right. So if the insurance company is denying that it happened at work, let's go with this example. Let's say you report an injury at work to your ankle because maybe you twisted your ankle, and the insurance company is like, well, it seems like you twisted your ankle maybe on a basketball court or not during work hours. No one saw you twist your ankle. You reported it afterwards, and you tell them, well, I thought I would get better, but it got worse. It ballooned up to like the size of a grapefruit. They're going to fight whether or not it actually happened at work, whether it was industrial, whether your injury was the cause of, whether the cause of your injury was because of your employment. So your injury has to be because of your employment, injury or illness. So that's the third thing we're discussing today. If you are an employee, and if your employer does have insurance, then the last thing is your injury or illness has to be because of your employment.
Yeah, it's that simple. I mean, it's a no-fault system, so you just have to prove, and you as the employee, you have to prove this. So you got to report it right away. Don't leave any doubts in your employer's mind that it didn't happen at work. Because if you do that, the adjuster's going to say, oh, well, I think I'm going to deny this. There's no factual evidence that this occurred and is related to work. We think it was related to the basketball game that you were at. And look, don't be lying, because if they find out that it was related to the basketball game.
Fraud.
It's fraud.
Felony.
In
the state of California.
And I've seen workers prosecuted for that.
Yeah. It doesn't happen often, because this is what I tell my clients, and I'll just give you a little tidbit for depositions. Don't be nervous. Don't be scared about fraud or perjury during a deposition, because if you're telling the truth, then it's not a lie. If you know and think you're telling the truth, it's not a lie. There's a difference between giving false information and telling a lie. When you lie, you're trying to intentionally deceive someone. If you yourself have false information, it's just not true, but you believe it's true, and you just repeat that information, that's not a lie. So, it's very hard for you to be convicted of fraud and of perjury if you weren't trying to deceive someone. But when you're intentionally trying to deceive someone, you got hurt on the basketball court, and somehow there's footage of that, and, the insurance company gets a hold of that, that's a bad day for you. Not for your attorney, unless he was in on it, which I doubt, but it's a bad day for you. It could lead to fraud. If you were to make that statement during a deposition, it could be fraud and perjury, both felonies in the state of California. So once again, be honest about your injury at work. But if you did get hurt at work, what you can do is, even before reporting it at work, if you go seek treatment on your own, let the doctor know. So you have a medical report stating, I was injured at work. That's a medical report that later on you could show them and say, hey, before I even filed for a claim, before I even spoke to an attorney, I went and I sought out medical treatment for my industrial injury.
Yeah, don't be telling the medical provider that you're seeing that it's related to something else, though, because if that's uncovered, I mean, boom.
Yeah.
I mean, they're going to say, oh, it's related to basketball. You told the doctor at the hospital.
Yeah.
And you might be concerned. You might be concerned that they're not going to treat you if you tell them that it's work-related. But if you go do that, and you tell them it's non-industrial or not work-related, it's related to something else besides your employment, don't go and try to file a workers' compensation claim after that. We got to get a lawyer. You got to have them look at that very closely to determine, what your stance is going to be on that claim.
Yeah. So those are the three things, as we said, the title for this is 3 main things that you need to know that are necessary to obtain workers' compensation benefits. Of course, we could be here all day talking to you about things that you have to do to continue your benefits, keep on going to your doctor's appointments to continue your temporary disability benefits or any type of benefit. But these are the main things to get started. Now, Alex mentioned several times that this is a no-fault system in California for workers' compensation benefits, and he is entirely correct. I do want to point out, however, that there are those exceptions, right? Affirmative defenses that the defense has. We had a video on that, Alex. What number was that? Off the top of your head, you don't remember? No. We'll put it right here. This video right here, we'll talk to you about the affirmative defenses for a workers' compensation injury. So although it's a no-fault system, if you are drunk at work and you get injured, not going to be covered. If you're horse playing at work, injured, not going to be covered. Several of those types of situations are not going to be covered, but for the most part. And the main things that you need to have is, 1, be an employee. 2, make sure your work has, or your employer has, workers' compensation insurance. And 3, make sure that you prove and that your injury is because of work and it's industrial.
Yeah, if you got those 3 things, absent some exceptional circumstances,
right,
You're going to have workers' comp coverage. It's supposed to protect you. We highly encourage that you contact a workers' compensation lawyer if you have any questions. Remember that this is not legal advice. This is a general discussion that George and I put together to educate you so that you understand more about the workers' compensation system and that you probably need to talk to an attorney if you have concerns. We have an injury helpline for that. Dial 844-984-8414. Give us a call. We'll give you a free case consultation. We'll listen to the facts and circumstances of your case. We'll give you that feedback that you need that is legal advice that's going to help you protect your livelihood and protect your workers' compensation rights.